My name is Jim Mooney. I'm a deputy director with the New England Association of Schools and Colleges, most particularly with the Commission on Independent Schools. And it's my pleasure to welcome Brian Garrett as today's speaker for our webinar. My experience with his firm goes back to my time as head of school at Vermont Academy, and it has always been eye-opening, to say the least, to work alongside of Brian and his colleagues. We are fortunate. We have an hour together looking at an issue which several years ago wasn't on our radar and now is front and center. I see that many of you have done the chat hello. I'm going to now just turn it over to Brian. He'll explain a little bit about the question and answer feature. I'll be hanging in the background, paying attention to questions as they come in, and there will be some time at the end as well. But let's start. And Brian, welcome, and thank you very much in advance for the work that you're doing and for the help you'll give us today.
Thanks so much, Jim. And thanks for everyone else joining on here today. Let me just start. Quick couple words about myself. Brian Garrett, I'm an attorney. I work at a law firm called McLane, Middleton. Right now, I'm situated in Manchester, New Hampshire. And our firm has several offices kind of in New Hampshire, Massachusetts, and it does all sorts of work, all the traditional things that you think a law firm might do, from litigation to trust and estates and whatnot. But we have this niche practice group. It's almost like a boutique firm within a firm that is just dedicated to education law, and even more specifically, K through 12 independent school law. And I'm the chair of that practice group. Now, what we do as part of this practice group is we work with schools all over the place. That includes certainly schools all over the New England region, kind of New Hampshire, Massachusetts, Vermont, Maine, but it spreads throughout the country. And indeed, we do international work as well. And the types of schools we work with are all over the map. Could be K through 12 day schools. They could just be upper school prep schools, boarding schools, Montessori schools, whatever. And we'll do any kind of issues that are sort of percolating through the school, whether it's a student parent issue or employment issue, a board governance issue, crisis management. And so because of all the work we do, we see these trends and we see these issues kind of coming down the pike. And that is clearly what's led to this session here today on this issue of race and admissions, assessing the impact of this case that came down in the Supreme Court last year on affirmative action at Harvard University, as well as the University of North Carolina. And so we're going to be spending some time today kind of unpacking a little bit of the case, more looking at what are the impacts of it in the aftermath. Right? It has almost been a year since this case came down. It came down in late June of last year. A lot of time has gone by. In fact, a lot of schools on the line right now have likely gone through admissions cycles in this new reality. So I think it's a perfect opportunity for the folks who are on here today to kind of get a pulse of like what's happened and how does this impact us at independent schools. And I will say this up front, and I will say this often. The Supreme Court case that came down last year has very little, if no, direct impact on the majority of schools that we service, independent K through 12 schools. And I'll talk about why, but then I'll talk as well about the context and the indirect impacts this might have. But let me start here, right? This is a case study that had with a real school 2 years ago. And let me just read it for the folks, to kind of get through this. It's called Race Conscious. It's been a long and fruitful admissions season, and you and your colleagues in the admissions office relax as you have received all replies for your next class. Then you receive a call from a disappointed parent of an Asian American applicant who was denied admission to your school. The parent is asking pointed questions about the use of race in the academy's admissions process, claiming that he is aware that less qualified African American students were accepted over his daughter. He claims that he is in the process of engaging an attorney who will assert that any use of race in the academy's admissions process is illegal. So maybe this has happened to you. Maybe you're worried this might happen to you. This certainly happened to a school that I had worked with. And again, this sort of came through a version of this 2 years ago. Now, in that span, things have changed quite drastically in the overall landscape of sort of affirmative action and race conscious admissions, again, as a whole, based on the Supreme Court case law that came down last year. So what we're going to be doing over the next, 50, 55 minutes or so here is talking a little bit upfront, just what is that legal framework? I'm going to spell out some of the laws, some of the case law that's been out there. I'll try to move through that briskly so that we can then focus a little bit more on the case that happened, but then the fallout from that case. What has been the guidance that has been issued by the federal government, by state governments, and what is the onslaught of litigation that's happened? Because there's been a good amount since the decision last June. And then I'm going to talk a little bit about, all right, so how does this impact independent schools? Because again, the case itself dealt with a private and a public higher education institution, right? There was no direct impact on an independent K through 12 school for the most part. So I'm going to talk about, well, then how does this impact you? And then leave you with, all right, so what are some of the practical tips that you can be thinking about as you continue to move forward and deal with this issue in the years to come, right? As Jim mentioned, I'll be sitting here talking and doing my thing. I have slides that I'll go through. I want this to be as interactive as it possibly can. And to that end, do not hesitate to have questions. Use the Q&A function. That is the best way to get questions our way. We'll be monitoring it. We'll take some questions as they come up. Maybe some questions we'll leave towards the end. But feel free to make this interactive to kind of help you as we think about this topic here. And the other thing is this is being recorded and you'll have a slide deck afterwards. I get that question a good amount. So I'll make sure that you have the slide deck and you can have that walking away from the session here today. So let's start, right? The legal framework of, and I'm going to say shorthand, SFFA, it's kind of a mouthful, but for Students for Fair Admissions, right? Those are the cases that came down last year in the Supreme Court. So what is the legal framework of that? And what I'm really going to be doing over the next handful of slides is just looking at what are the laws that apply to the world of affirmative action? How is that interpreted in the courts historically? And then what has been the case that came down last June? What was it? What was it about? What were the findings? What were the holdings? And then we'll move on towards the next section. So in general, there are a ton of laws that basically say schools, hey, a lot of different institutions, you cannot discriminate on the basis of race, pure and simple, right? Some of them are federal laws, right? And we have here Equal Protection Clause of the 14th Amendment. That's a constitutional law. Federal law, we have Title VI of the Civil Rights Act. I'll talk about that in a second. Section 1981. I'm going to be spending a good amount of time on that throughout the program today because I think that's where a lot of my focus has been on, is Section 1981. It could also come from IRS. They have guidance that basically says you want to be a tax-exempt institution, you need to have a non-discrimination statement as it relates to race, national origin, ethnicity. And there's also going to be state laws that can apply here too, saying you can't discriminate on the basis of race. Now, I want to unpack those just a little bit here before we kind of move more into the substance, right? The big one in what you'll see often in the Supreme Court is the Equal Protection Clause of the 14th Amendment that essentially just says that no state, so a state, some sort of public sector institution can deny any person the equal protection of laws. Right? This is going to apply to just public schools. So for the big case that came down last year, that would have been UNC, University of North Carolina, was a defendant in one of those cases. Second one, Title VI. Right? This is of the Civil Rights Act of 1964. I won't read all this, but you got it. Basically, again, says you can't discriminate or to exclude people on the basis of race. Right? Now, this is a law, federal, applies all over the country, but only to schools that accept federal financial assistance. That's going to be a common theme of what I'm going to come back to throughout the course today, federal financial assistance, those who accept it, right? So for the most part, that is almost every institution of higher education. That is Harvard University. right? They are a private institution. They're not public like UNC, but they are a private institution that accepts federal financial assistance. Therefore, Title VI applies to them. Now, this is the other law that I want to sink my teeth into a little bit, because I do think that this is the law that's going to ultimately apply to independent schools way more than the other two ones that I just referenced. Right? This is Section 1981. This is Section 1981 of the Civil Rights Act of 1866. Right? This is Reconstruction era laws that basically say all persons shall have the same right to make and enforce contracts as is enjoyed by white citizens. Right? Very clearly aimed at mitigating the wrongs of slavery and the injustices of African-American individuals in the country, allowing them to be able to buy homes and buy land and property. Right? That was the emphasis of the law back then. But this can apply to any private entity, including independent schools. Now, that is the law that can apply. Has it been applied to schools? Have we seen it before? Really, really rarely, right? It is not one that pops up at the Supreme Court, certainly as it applies to schools, if ever, right? Like it never has. The biggest case and the most instructive case is the one I have in front of you right now. This Kamehameha Schools one. This is from Hawaii back in the mid-2000s, where this Hawaii school was founded a century prior in the 1800s, really to benefit Native Hawaiian students. And they had preferences in the admissions process for Native Hawaiian students. Well, naturally, non-Native Hawaiian students brought forth a claim against the school saying, hey, you're discriminating against us. We're white individuals on the basis of our race, and that is in violation of Section 1981. And this is a case that was litigated in the District of Hawaii in the federal court, and then it was kicked up to the Ninth Circuit, which covers Hawaii and the West Coast. The Ninth Circuit said, whoa, 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 whoa. No, this does not violate 1981 in this section there. And they gave a lot of reasons for it, right? One of them, and I'll quote it here, clearly important to the court's decision, was that increased primary and secondary school educational achievement by minority groups can obviate the downstream need for affirmative action programs by employers and institutions of higher learning. Right? They base this on a reading of other federal laws in saying this does not violate. This is narrowly tailored in such a way to benefit this one particular group for this one particular reason that is of a very compelling interest to our society. Right? So that ruled in favor. That's been it. It's been quiet on this front until very recently. And I'm going to come back to that in about 15 minutes or so. So that is that Section 1981. That's independent schools. But of course, we've seen a whole bunch of other stuff out there historically as we think about affirmative action in cases that have gone up through the Supreme Court and issues that are in front of colleges and universities for the most part. Right? There have been landmark cases. I have them here. We have the Bakke case from the mid-70s, where basically the Supreme Court said, hey, using race, that can be a justifiable issue in admissions, but you can't set quotas. You can't say we need X% of our students to be African-American or Asian-American or Hispanic or whatever. Right? So it did open the door. Michigan was another one that came up. That's the Grutter versus Bollinger in the early 2000s. Where again, they said, hey, this can be a compelling interest, right? This idea of getting the educational benefits that flow from a diverse student body is something that really is something that we need to be striving for in our government and in our communities, in our society. And so there, again, the Supreme Court said, this is okay. This works. Right? They basically said, you can't set quotas and you can't have, certain kind of measurements that you need to hit, but using race can be a plus factor as you're looking at everyone else, even if it's a tipping factor in favor of admitting one student over another. That has been the lay of the land until last year, right? When this case, Students for Fair Admission filed a lawsuit. This is a lawsuit filed by a nonprofit group with conservative leanings by a guy, Edward Blum. He created Students for Fair Admissions. And they specifically sued UNC, pretty much the oldest operating public school, and Harvard, the oldest operating private school. They sued both of them back in 2014, and this spent its time working its way all the way up to the Supreme Court. They lost at the district levels and the federal levels based on all that precedent I just talked about. Oh, I'm sorry, at the appellate level, they lost until it got up to the Supreme Court last year. And basically what they were arguing is any use of race at all is patently illegal. Can't do it, right? And both Harvard and UNC said, whoa, 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 we have all this precedent under the Supreme Court. What we're doing is in line with that. It's justified. It's used as part of a holistic process for doing our admissions program. So we should be fine. And of course, as we know, Supreme Court said no. You can't do that, right? They held both programs illegal, sort of upending how we are to view the use of race in admissions programs. Now, what they basically relied on was three different criteria. There's three primary justifications in the primary holding, the main opinion of the court, which was written by Chief Justice Roberts. The three reasons that he was saying is that first, the programs were not operated in such a way that could be subjected to meaningful judicial review, primarily because they were not sufficiently coherent to be measurable, like the reasons for doing this. And the programs did not articulate kind of any connection between the means of using race and the goals that they pursue, and that this was just sort of imprecise and opaque. That was kind of the main first reason of why they upended this and said this was illegal. Second, they said this, reinforces negative stereotypes, just to simply say a whole block of students of one race should behave in one way. That was the rationale for saying that that was kind of an impermissible stereotyping that was unconstitutional or in violation of Title VI. And then third, basically saying, to what end? When is this going to end? In the Michigan cases back in the early 2000s, Supreme Court Justice O'Connor, Sandra Day O'Connor, had said in a footnote of one of those cases, in 25 years, hopefully we'll never have to do this again. Hopefully we don't have to use race. And I think the Supreme Court kind of harped on that here, saying it's been 25 years. We're still kind of in the same situation. What are we going to do? Another 25 years? When is it logically going to end that we have to use race? Which, of course, as we said earlier, is kind of against any of those laws that were set forth. So that was the main holding. Where I'm going to focus on now is some of these carve-outs that were really interesting. One was, he kind of sandwiched this right at the end, Chief Justice Roberts, talking about, well, what's being carved out of our opinion is how an applicant can discuss how race has impacted their lives. And let me quote this. He says, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. It's notable that he put this in because that opened up the door for how are schools handling this now? It's also notable because this was actually a concession that SFFA made during oral arguments. They kind of said, oh yeah, this is fine if schools do that. So the court kind of had to borrow that and put it into their opinion here. But clearly this has created a huge uproar, or at least this has had lasting impact of how schools have been trying to deal with the ruling. The other carve out in a footnote was that military academies were not subject to the ruling. And to be clear, this ruling really does impact any school or college that's either public or accept federal financial assistance. And of course, military academies are those. But in a footnote, he said, no military academy is a party to these cases, and none of the courts below address the propriety of race-based admission systems in that context. This opinion also does not address the issue in light of the potentially distinct interests that military academies may present. So these two big carve-outs that are really kind of interesting. And we're going to spend a lot of time on the first carve-out, but I'm also going to circle back to the second carve-out, and you'll see why as we talk about some of the ongoing litigation that's been going on here. So let's get to some of those issues now. what is the fallout of all of this? Right? This is sort of the meat of kind of where we have been over the last several months, because this bombshell came down at the end of June. And of course, a lot of people went scrambling, being like, well, what does this really mean? I mean, obviously, people are on the line here today trying to figure out, well, what does this mean for us, even in an independent school world, but certainly colleges and universities were thinking the same thing. They're having that question. So, in the wake of it, there was both political guidance that came out to try to give some direction, primarily again to colleges and universities. And then there's been this ongoing litigation that I've been referencing already, because again, it's just been wild to see all these cases that have been filed. And I'm going to go through all of those. First, the guidance, right? There's been federal guidance issued by the US Department of Education and the Department of Justice. They came together basically in response to President Biden kind of declaring and directing them. Right after the ruling came down, so late June, early July, the White House came down and said, hey, DOE, DOJ, you need to put together guidance. So they put that together and they came out with it in August. It's kind of an FAQ, which you can look up, and it can be very helpful, right? What it is stressing in that FAQ is the ruling has to do with just using race in admissions for colleges and universities that are either public or take and accept federal financial assistance. But it's just about using race in that admissions process. It's a whole lot of things that that case does not directly implicate. And they discuss that here, right? What it says is, hey, schools, what you can do is you can do all these things. You can assess how an applicant's background position them to contribute to schools, very much borrowed from that language I talked about a couple slides ago, right? This carve out, right? Borrowing the carve out from number one, the applicant's discussion of how race impacted their lives, right? So it says you can do that. It says you can collect data as well, right? If people are doing the Comment app, still a button there that says they can select race. Or if you're using your own application, you can ask people for race, you can take that, right? You can collect that data. Now you can't use it. You can't use it in the admissions process, but you can collect it. And that's where it gets to be pretty tricky for schools. Like, how can we collect it and then not really use it, right? We know. So anyway, that's a big debate for a lot of schools, but at least the guidance says you can do it. You can also, and they encourage schools to think about what are all the barriers out there to students of color or other minorities getting into your schools. Things like legacy and donor preferences. That comes up a bunch. You probably heard that in the news, and we'll talk about that in a minute. But it can be application fees, like the monetary amount, students who are having to pay hundreds of dollars just to apply to schools. Early admissions, there's data tending to indicate that favors wealthier students, non-minority students, maybe athletic preferences as well, right? Again, students who have the capability to spend a lot of money growing up playing different sports tends to impact minority students who might not have, or other students that are less wealthy, or applicants that are less wealthy. Right? So it's basically reconsider those things, maybe remove some of those barriers. They also say, reach out, create pipelines, work in such a way where you can broaden your pool of applicants. And this is very true in the employment context, right? For decades and decades, it's been old hat. If you want to make an employment decision, you can't use race. You can't look at someone's race and say, we need to hire someone because, we need, more people of a certain color or ethnicity or whatnot. Like, that can be patently illegal in a way that it now is in this admissions process for education. Nonetheless, for decades and decades, many institutions, many corporations, Fortune 500 businesses, schools, whatever, have clearly said, well, we want to broaden our pool of people that can come work here. We want to have diversity. We want to go to diversity conferences, open up job fairs, figure out ways that we can get more people from minority backgrounds to apply to our jobs. Well, nothing illegal in the employment context, just as there's nothing illegal in the admissions context for education, right? So you can still do that, right? And focus on not only getting kids in the door who may be minority students, but then how do you keep them there? How do you make sure they have a positive experience there? How do you, provide ample resources to support and affinity groups? So that was the federal guidance that came out in August. for folks here in New England, there's state guidance too. It's came out, I think the only one so far has been Massachusetts. I don't think it's come out in any of the other states. I apologize if I'm wrong, but Massachusetts came out in October, right? With the Attorney General, Andrew Campbell, and then the Governor Maura Healey. They came forward with guidance and advice on this that very much mirrored the DOA and DOG advice. Again, kind of specifically for colleges and institutions. But a big emphasis of that advice was to focus on the K through 12 approach. Like, how do we help K through 12 schools in their efforts to increase access for and supporting historically underrepresented students, right? The guidance says, colleges, universities, you need to be developing really strong relationships with schools so that you better understand where these kids are coming from. And they also say K through 12 administrators, teachers, counselors, staff, whoever, like, you can take targeted action so that students from underserved communities are aware of, have access to, and can participate in the college preparatory process. Now, of course, a lot of that guidance was aimed more, even at the K through 12 level, on public schools, but it's still, I think, wildly helpful for independent school administrators to be looking at that. It's like, okay, what's out there? Just kind of what do we need to know as, these other, political bodies are thinking about this. Now, I will say one other caveat is that this is just political guidance. We all know this is an election year. Next year we could have a very different government, all the way from the federal level, probably less so at the state levels here, but nonetheless, these things can change and guidance can change and it can flip-flop. So this is not law. This is just guidance. So where is the real legal guidance? Well, that's coming through this, what I've called now, this onslaught of litigation that's happened in the wake of everything that's, of the decision that came down and the guidance that kind of came out in the last, 8 or 9 months or so. And these cases are coming from all different angles. I'm going to spend the next 2 slides talking a little bit about some of the cases. This first slide is very generalized cases that apply primarily in the education context, but again, apply primarily in the public school context, public higher education institutions, or private institutions that, again, accept federal financial assistance. So what are some of those cases that have come down? Well, there's one, the only one that relates to a K through 12 school that I'm highlighting, at least for now. There have been some others, but the one I'll highlight, at least for now, because this has the possibility of going to the Supreme Court, is the first one on your screen, right? That's the Coalition for TJ versus Fairfax County School Board, right? This is a claim that Thomas Jefferson School, which is based in Northern Virginia, it's one of the highest ranked public schools in America, changed its admissions programs to kind of get a broader swath of students, focusing less on white and Asian American students and more on, African American, Hispanic students through their admissions pipeline. And they changed the admissions criteria and they were sued over that. They were sued for violations of the Equal Protection Clause of the 14th Amendment, very much like the University of North Carolina. Now, this went up to the appellate level court, the Fourth Circuit, and the Fourth Circuit in Virginia said, nope, or they're the one that oversees, the Virginia courts, said, no, this does not violate the 14th Amendment. It ruled based on a lot of the prior Supreme Court guidance. This isn't a violation of the Equal Protection Clause. The only catch is that ruling was in May of 2023, May of last year. Obviously, the Students for Fair Admissions case then came down in June of 2023. So the Supreme Court guidance has changed. Therefore, this case has been applied to go to the Supreme Court. I think we are still in the process of seeing if the Supreme Court will actually take it. So what are a whole bunch of other legal challenges, right? Ones that are not necessarily at the K through 12 level, but more higher ed. Well, I think the big one I referenced earlier and that you've likely seen in the press, a lot of discussion over legacy admissions. Now, this came with complaints, and these are not necessarily ones that are filed in court like a formal legal complaint. These are complaints that are filed with the U.S. Department of Education, one by the Chica Project, another by an individual from Penn, where they're basically saying, hey, Harvard and University of Pennsylvania, you're violating Title VI, that federal law that applies to schools that accept federal financial assistance, by using legacy admissions, right? Because that only, or it has a disproportionate impact on, white students, primarily wealthy white students. So those are ones that the DOE said, hey, we'll look into. So they are in the process of reviewing that right now. We're not sure where that's going to go, but that's a hot button issue. Another one is this military academy issue, right? I mentioned a few slides ago the carve out in the opinion from the Supreme Court case last year was this isn't applying to military academies. Well, of course, 2 months later, the same nonprofit action group, a conservative action group, SFFA, sued West Point and the Naval Academy, saying, hey, the Fifth Amendment, it applies to federal entities, and both West Point and Naval Academy are federal entities. They can't, discriminate on the base of race. So again, those cases have now been percolating through the courts. They were sped up through the Supreme Court. The Supreme Court came down a couple of weeks ago saying, we're not going to block the admissions programs right now. We're going to let this take its time through the courts before we address this. So you may have seen the Supreme Court denies those cases. It just basically said, we're not going to rule on them right now. Let's let the trial courts and then the appellate courts figure this out, and then we'll see if we need to hear this out. But again, yet another one that's kind of going up on the military academies. And the last one on this page that I'll throw out there is this America First Legal, which is another sort of nonprofit group. This one was formed not by Edward Blum, but by Stephen Miller of, famed speechwriter for President Trump, where they brought a claim against NYU, specifically the law school, and more specifically, the Law Review, kind of the editorial magazine that is made up of students, and they have a mission of being a diverse body on the Law Review. And you had a white student there saying, hey, this is impacting me because you're focusing on diversity, racial diversity, as well as LGBTQ diversity. And that's in violation of Title VI and Title IX. So all this to say, all these things are coming up. Now, those are all claims under Fifth Amendment, a little bit, I mentioned. Title VI, or the Equal Protection Clause, similar to Harvard or UNC in the SFFA cases. But what I have had my eye on the most are these 1981 actions, right? Section 1981, this is that federal law I mentioned again from 1866. That was the basis of that Kamehameha Schools case in Hawaii back in 2006, right? Again, there has not been a lot of legal action on that in historically, until now. And there's been a lot of cases that have come down. One of the case, not in the education context, but in more corporate contexts, is this American Alliance for Equal Rights versus Fearless Fund Management. American Alliance for Equal Rights, that's yet another nonprofit created by Edward Blum, the man behind Students for Fair Admissions. And that was suing a fund that was sponsoring a $20,000 grant that was focused on African-American women entrepreneurs. Saying you're an African-American woman entrepreneur, we have $20,000 grant that you can be eligible and you can apply for and that we will give you. Well, AAER, American Alliance for Equal Rights, sued. And in fact, not only did they sue, but they sought an injunction, meaning stop, can't do it right now. And the courts got up to the 11th Circuit, said, yeah, you got to stop doing that right now, Fearless Fund Management. You can't be doing that. That seems to impact and potentially violate Section 1981. So they stopped the fund from giving out that grant on an indefinite basis, while the case now goes through the court system to figure out, is this really a violation of Section 1981? That's the one there. There's been a whole bunch against law firms that I've had my eye on. I work at a law firm. But all these law firms, all by the same AAER nonprofit group, one against Morrison and Forster, another one Perkins Coie, and another one Winston Strawn. where they all had fellowship programs where they were basically saying, hey, we will give money for people of certain backgrounds to be able to kind of work here. It could be based on ethnicity, it could be based on race, it could be based on other factors. And what the plaintiff said is like, no, again, that violates when you're focusing these fellowships on those specific subgroups, that violates Section 1981. And in fact, all three law firms said, we're not dealing with this. And they revised their fellowships to say anyone can apply. And, because of that, all the cases were dropped. So that all happened kind of over the late portions of 2023, seeing that in action, again, under this novel law of Section 1981. So I have now spent about 40 minutes talking about, what is the legal framework and what has all this amounted to in the past 8 months? Like, where is this all going, right? As a general thing, kind of give everyone an update on just what is the bare bones basics of what happened and what's happening now. I do want to spend the last 20 minutes here now transitioning our focus and focusing it much more in on how does this impact you? How does this impact independent schools? And I just want to pause just in case, there are any questions that are coming in. I don't know if I have seen any of them come in. I haven't seen anything so far, but if you have any of them, by all means, send them in and I'll continue to kind of move forward as we think about, all right, what are the practical implications now to you at independent schools? So it's a big threshold question. It is the threshold question. Do you accept federal funding? Like, do you accept federal financial assistance? As I said repeatedly now, the case that came down last summer involved UNC, a public entity that's not going to impact any of the schools that should be on this broadcast right now. Independent schools are not public entities. But Harvard University was a private entity that had accepted federal financial assistance and therefore was subject to Title VI. And so the ruling that came down last summer impacts any other entity, any other school that accepts federal financial assistance under Title VI. Can't discriminate on the basis of race. So a fundamental question for your school is, do we accept that? A lot of schools will say, I don't think so, but I'm not sure, right? And this is the opportunity. One of the big takeaways that I'll have for you coming out of today is get your business office on the phone, figure out, where is money coming into our institution, right? Because if you do accept federal financial assistance, you must comply with SFFA. So all that political guidance, all the other cases that were kind of percolating, everything that you've seen out there, that would apply to you no differently than it would apply to Harvard or Dartmouth or UPenn or, University of Massachusetts or wherever. So you should know that. If you don't accept federal financial assistance, well, the case does not directly impact you. And again, that is going to be the vast majority of schools that I work with and likely the ones on this broadcast here today. So it doesn't directly impact you, but that's not the end of the game. You still got to conduct a risk assessment. Like, it doesn't impact us now, but do we want to change anything? I'm going to focus on that in a minute, meaning like, what are the things you could do and you might want to think about doing? But let me just take another couple minutes here to kind of just unpack what is federal financial assistance for all those schools that were kind of saying, I don't think we accept it, but I just don't know. Right? This is something, federal financial assistance, that's defined under various laws and regulations. And it's usually the same definition. And it's very long, but it's very specific. And it'll say, in essence, this first bullet and sub-bullet that I have here, right? It's assistance in any form of any grant, loan, or contract. It can be financial, but it can be other things. I work with, military academies, right? They take federal equipment in the form of like uniforms or personnel. Like that can be federal assistance that they accept. Or it can be a grant of property that came from the federal government. A lot of times, this can be money that's filtered through a state government and sent to you. You got to really kind of dig into the weeds. But what do we know it includes? What do we No, it doesn't include. There are a handful of things, right? So number one, PPP loans, National School Lunch Program, right? Everyone who got a PPP loan, I think we were all pretty well aware in the application form, this will impact, this will be implicated as federal financial assistance, and therefore you need to comply with not only Title VI, but Title IX, Section 504, other federal laws, right? So those things, National School Lunch Program, there's been case law that has pretty clearly said that too. If you accept money through the National School Lunch Program, that is federal financial assistance. You are therefore obligated to follow, the case law that came down last year. What doesn't it include? Well, we've also got pretty good guidance of Title I, Title II, or Title III funding under the Elementary and Secondary Education Act, the ESEA. There's been pretty good guidance saying that that money that comes in, that's getting flowed to an employee or to a student. That's not getting sent to the school per se and should not be characterized as federal financial assistance. Same thing with the employee retention tax credit. Now, there has not been clearly definitive guidance on the ERC, but by and large, most readings of this are, if you are taking advantage of that sort of tax subsidy, that is not going to implicate federal financial assistance either. So those are ones where we feel relatively good knowing what is and what isn't. But where are we unclear? E-rate is one, right? E-rate relating to kind of technology resources and internet on campus. This is one where various courts have had various responses of whether that's federal financial assistance or not. So there's kind of a split on that. Same thing with FEMA grants, right? A lot of schools are saying, oh, we could get money through FEMA. Now, the application process and the documents don't clearly say whether that's federal financial assistance or not, but it probably would be characterized that. So something for schools to be mindful of and to be thoughtful of, like that could trigger it. The other big one that I'm sure might be on your minds, but maybe you've seen this percolating over the last couple of years, the other big cases that came down 2 summers ago, right? So 2022, were those cases, one in the District of Maryland, another one in the District of California, that both said, hey, schools were sued under Title IX because there was sexual harassment, potential sexual assault among students at the campuses. Something else was happening in California there about, discrimination against a student for playing on a football team. But the students there brought cases under Title IX, and the court said, yeah, Title IX applies, not because you've accepted anything that I've read on this slide so far, but by the mere fact that you are a tax-exempt entity. That is federal financial assistance. Therefore, you particular schools are subject to these non-discrimination laws like Title IX in those cases, or maybe Title VI in this case. Now, I'll give a couple caveats to that. Number one, those 2 cases only apply to those 2 schools and those 2 jurisdictions right now. It doesn't apply up here in New England. That's not to say some court up here might see those a similar case and rule differently or similarly to those cases, but it's not binding on any schools up here. Another caveat, the one in Virginia is going up through the 4th Circuit. It's been argued right now, and we're waiting to see what the 4th Circuit will say on that. I know a lot of the national organizations are, weighing in on that, really trying to say, hey, nonprofit status should not equate federal financial assistance. The third caveat that I'll say about it is that there's been a recent case in Arizona that came out that then ruled against those 2, that said, hey, the sheer fact that you're a nonprofit organization does not mean you have federal financial assistance. So it kind of undermined those. So we have this sort of split amongst districts around the country, leading to a big question mark here. So let me pause because I do feel like I've seen a couple things.
Yeah, we have 2. We do have 2 questions, one from Peter and one from Rebecca. If you'd like to take a look at that.
Yeah. So, Peter, let me restate the question. Well, let me just state the question. Let me kind of restate it as best I can. If you cannot discriminate on the basis of race, but can take account of someone's race in the application process, and you want a diverse, racially diverse student body, can't apply quotas, How do you know which races you can discriminate in favor of? Kind of a loaded question. Again, number one, are you a school that accepts federal financial assistance? Then you're very clearly going to be more mindful of how you're applying race at all in the admissions process. Again, the carve out is, if some student writes an essay, and I'm going to talk about some essay prompts in a moment, but if some student writes an essay saying, because of my upbringing as the only Black student in an all-white school, I learned about, others' viewpoints and challenges and blah, blah, blah. If you take that, you can be admitting that person, but again, not because of their race, but because of the adversity and the challenges and the growth in character, right? Those are the reasons that you can be doing it. You can never do it based on race if you're subject to Title VI, right? In the way that Harvard was. If you're not, if you're just an independent school, you can still take account of students' races. Like, that's out there. That's been traditionally what schools have done. And there's no legal guidance yet that says you can't. That's not to say someone might not raise a claim about that, but that's no different than someone suing over any other issue like Title IX or other things that you might not be bound by. So there's that issue. So just, understand that nuance, and it is kind of a finicky nuance. What Rebecca had asked is, if you took PPP loans during the pandemic and they were forgiven, and that includes FFA, does that designation last, or is there an end date to the loan? Phenomenal question, Rebecca, right? There, the guidance was crystal clear. You were subject to the federal non-discrimination laws by taking the federal financial assistance of the PPP loan only until the loan was fully forgiven or fully repaid. Once that was happened, you should have gotten a document saying, stamp of approval, you're forgiven, and you were done. So it no longer applies. Now, you might get a claim of someone who says they were discriminated against back in 2021 at your school when Title IX would have applied, and you'll have to deal with that as it comes. It can look back historically so long as it's within a statute of limitations period, but that'll get smaller and smaller as we go on in time. But for right now, you should no school really, as far as I'm aware of, is still subject to those requirements. So we have 10 minutes left. Let me go through some of the practical things that you can be thinking about doing. Right? Again, this is coming at this from a perspective of the majority of schools I work with, independent schools that were not directly impacted by the court case last year. What do? Now is as good a time as any to kind of get a better understanding of what do you do at your school, right? Maybe you already did a lot of this back in November or the beginning of the admission season, but like, are you asking about race, ethnicity, color on your application process? Are you asking for photographs or videos where you could see someone's race or ethnicity as part of that? Okay, well, like, are you doing that? Well, sometimes, some schools may say, we just want to make that optional. We don't necessarily want to do that. Some schools might say, we just don't want to poke the bear at all. We're really risk averse. We just don't want to ask that anymore. A lot of colleges certainly went in that direction because they're bound by the guidance from the Supreme Court case. Whereas other schools I know say, hey, we're gonna dive in head first and say, we want to be racially diverse. We're using race as part of our admissions process. We want the whole world to know that. They don't care if they get a claim, if they get a lawsuit thrown against them. I've seen some schools say that. So be it. It depends on your risk aversion. But this is a good opportunity to do the audit of, what do you ask for, and do we need to reconsider it? You should also be thinking, like, again, to that point, not only are you collecting the information, but are you using it? Are you actually considering race in the admissions process? Are you considering any other preferences that could tend to benefit more wealthy, white-leaning applicants, like legacy, like donors, like employees' children, like students who come from tons of athletic opportunities? Right. So do you have really high application fees, things of that nature you could be thinking about, as well as what is the impact on financial aid? This is a huge question mark coming out even for colleges and universities. How do we deal with financial aid? Again, the case last year did not directly implicate financial aid. It only said you can't use race in admissions. So can you use race as part of a financial aid process? A lot of colleges and universities are trying to figure that out right now. And some are already saying we're not going to, whereas others are saying we're going to continue because, we have a mission here and we do want to have diversity on campus. And this is a big part of getting diversity is to know someone's race. So independent schools, again, who are not subject to that ruling from last year, have a little bit more leeway here, but it's still kind of a fraught sort of terrain. One thing I want to go to is the essay prompt question. Right? This is a big thing for a lot of schools, colleges and universities. Right? They changed a lot of their college essay prompts kind of leading into the fall. And I've gone through, I pulled out a bunch that I thought were kind of helpful to think through. Right? Johns Hopkins here says, tell us about an aspect of your identity or a life experience that has shaped you. Again, this is calling back from that carve out that Roberts has in the opinion from that Harvard case. Duke said, feel free to tell us any ways in which you're different and how that's affected you. And again, sort of not asking about race, but giving students the leeway to talk about it. Sarah Lawrence came at it head on. They literally quoted Roberts from the opinion and then asked the applicants to describe how they believe their goals for a college education might be impacted, influenced, or affected by the court's decision, which is wild. There's a whole bunch of others that I pulled that I don't have here, from Babson to Columbia to Emory, ones that are very helpful, I think, for independent schools to just know what our college is asking. And do we, as independent schools, want to maybe have similar questions for our own applicants at our schools? Or maybe we, again, having college counselors on the line here today, maybe they want to know. So do an audit of your admissions process. Another thing to do, evaluate your student body diversity on campus. But this is a time to not just have diversity statements for the sake of having a diversity statement. Get into the weeds. Have documentation showing why is this important? How is this important? What are the benefits of this? How have we measured this or made it objective? But these are things that you could do. Now, full disclosure, Harvard and UNC did those too, and they still lost the ruling. But I think you're going to be much more empowered by a potential litigant if you can just demonstrate the connection between diversity in your school's mission, than if you don't really have good talking points on that. Similarly, right? What about community messaging on all of this? This is a big thing again. Right when the case came down last year, schools were put in the position of, do we talk about this? How do we talk about this? Right? This is no different than BLM. This is no different than the Israeli-Palestinian conflict. Like, how do we talk about this kind of sensitive issue broadly? Well, we're kind of come and gone past that point in time. So maybe you borrowed some helpful talking points. I would always say, reach out to a professional PR company. I'm just looking at the list here. I apologize if I'm missing anyone. I see Philip Hauserman from the Castle Group on here. They do terrific work. There's other terrific providers that can help schools with messaging over these very sensitive cultural issues. But think about that. How do we address this? And when you do figure out how you want to address it, make sure you're all on board. Right? Make sure everyone in your admissions office understands, how do we talk about this when we get asked questions, like from my hypothetical on the very first slide, like, so that the people all the way down from the head of school all the way down to just your basic admissions officers or interviewers kind of know how to handle these issues as they come up, or where to direct families when that happens. So key things to be doing. Those are kind of generalized talking points. Generalized practical tips that I really think schools should be doing. There's a ton of other experts out there that I am not qualified to talk about in terms of how do you work diversity in on a campus, and how do you do that through either the admissions process or otherwise, right? Any one of those people or resources can be invaluable to schools, in addition to just sort of communications or, a legal perspective, which I can give. But here, if there's one slide that you can take away, right? Action items. Conduct that audit of federal financial aid. Figure out, do you accept that money? Okay. Now, closely monitor developments. All these cases on Section 1981 being a big portion of what I've talked about today. Are they going to slowly trickle in the independent school landscape, similar to how we've seen some of the Title IX cases trickle in throughout the other parts of the country? Right. Also, conduct your audit of admissions and financial aid. That was a slide I had 2 slides ago. How do we handle these processes? Again, thinking about community messaging, I just had on the last slide. And then, of course, just training and education for folks at your school, particularly your admissions team. Really key things that you can be doing to kind of make sure that you're staying abreast and dealing and coping with this new and evolving landscape. If you have questions coming out of this, here's my contact information. Feel free to reach out to me. We deal with these issues a lot. I can continue the conversation with you or help out on any other issues that you're facing on campus.